Yvette Flores.
Thank you. If you are not on the board, please mute yourself. Okay, so we're going to get started. My name is Mike Panessa. I am the chair of the Administrative Appeals Board. This is our regular meeting for May 25th, 2022. Sorry about that. First item is City Clerk, if you could call the roll.
Board Member Hedrick,
Here.
Board Member Moses,
Here.
Board Member Sinclair,
Here.
Board Member Vasili,
Here.
Vice Chair Kane,
Here.
Chair Panessa.
Here.
All members are present.
Thank you. First item on the agenda is the acceptance of the agenda. Before we take a roll call on that, I just want to let everybody know we are going to change the order. We're going to do hearing number that is number 5 on the agenda first. So can I have a motion and a second to accept the agenda?
So moved. So moved. Second.
Thank you.
I'm sorry, there are a lot of people on this call, so if you could please announce yourself when you make a motion so I can make sure I have
Steve
documented
made the
appropriately.
motion.
Thank you. And second,
Hedrick.
thank you. Board Member Moses,
Yes.
Board Member Hedrick,
Yes.
Board Member Vasili,
Yes.
Board Member Sinclair,
Yes.
Vice Chair Kane,
Aye.
Chair Panessa,
Aye.
motion carries 5-0.
All right, thank you. Item number 2 on our agenda is public comment. Excuse me. This time is set aside for members of the public to address the Administrative Appeals Board on agenda items. The items and items of general interest within the subject jurisdiction matter of this board. Pursuant to the Brown Act, it is generally, we cannot take any action on items not on our agenda, although we do value your opinion. Testimony for the hearings will be taken at the time of those hearings. City Clerk, is there anyone slotted for public comment?
We have no pre-registered speakers. However, I do see members from VRON in the room. So if you would like to speak during public comment, this would be the appropriate time. Please feel free to raise your hand and I will scroll through and unmute you as it is your turn.
Hello, Philip.
Vanessa,
Hi, this is Stacy from OJ Arabian Nights. Philip, are you online?
This is not your time to speak. This is the time for public comment. Your time will be coming up shortly. I will let you know when it is your time to speak.
Chair Panessa, I see no hands raised. However, like I mentioned, there are many people in the room. So if I did not see you and you do have your hand raised, please feel free to speak now for public comment only.
Thank you. Any comments on a particular hearing will be taken at the time of that hearing. All right, so if there's no registered people for public comment, we're going to move on to item number 5 on the agenda. And for the record, Vice Chair Kane will be recusing herself from this. Alternate Board Member Hedrick will be voting on this case. So I'd like to ask the staff for their report.
Good evening, Council. Good evening, Board. The matter before you is an appeal of Palm Springs Municipal Code 5.55200 A3 and A21 of the Cannabis-Related Business Code Regulations. This is the first appeal regarding a cannabis matter before you. Therefore, you will note that the packet before you is rather extensive. And while most items may not initially appear to be related to said appeal, they are all related and relevant to what is before you this evening. We have provided for you an extensive background of the code compliance implementation, the adoption of the fee schedule, and the extensive outreach that was provided to all cannabis business owners and stakeholders to ensure that they were aware of the code compliance enforcement that would be initiated once code compliance was hired for these positions. At this time, I would like to turn over the presentation to Deputy City Attorney Patrick Donegan, who will be going over the legalities of this matter. Thank you.
Thank you very much, Director Goodhart. Good evening, Chair Panessa, board members. My name is Patrick Donegan with the City Attorney's Office. I assist Director Goodhart and other city staff with implementing and enforcing the city's cannabis program. I did want to say, if anyone wants to interrupt and ask any questions, feel free. And as an initial matter, I would like to state that some of the comments made in written correspondence that I received this AM towards city staff and kind of the process relating to this administrative citation that alleged self-serving code enforcement officers or a Keystone Cops type approach couldn't be further from the truth. I'm not going to address every single point by point unless asked to, but I can assure you that the city, Director Goodhart, and staff take this very seriously, and their main goal is always compliance. The first step is always to reach out to the permittee, try to get the violation resolved on an administrative level without, draconian or more aggressive enforcement matters. And in fact, as Director Goodhart referenced, that's somewhat evidenced in the staff report that the appellant somewhat feigns confusion over that, hey, we didn't know what was going on, city never told us. That couldn't be further from the truth. And so, the city's patience for potential violations eventually runs out. And that's kind of what we have here tonight, when, the appellant blatantly and repeatedly ignored city's attempts, informal, to resolve this, continued to be an issue, continued to be a problem, and thus more serious enforcement measures had to occur. Here, that's the administrative citation that is being appealed before you tonight. So the appellant was issued a citation for two related but distinct Palm Springs Municipal Code provisions, both found in section 5.55.200A. Despite the appellant's contention, that provision does lead, the operative kind of clause states, throughout the term of the adult use cannabis permit, each permittee shall not violate this chapter, and thou shall comply with the following. It then kind of lists a rather extensive list of requirements that cannabis permittees must follow. And in this instance, the appellant was cited for violating two of those, subsections A3 and subsections A21. As I said, while they're somewhat related in that they address kind of the same public policy goal of the city council, they're distinct and separate requirements. Subsection A3 requires that each permittee maintain a register of names and information of various people related to their cannabis operations, including employees or people otherwise engaged by the cannabis business. Subsection A21 requires that any new employee submit information, including fingerprints and a live scan, for a background check to the city 10 days prior to commencing employment, and that no permittee employ or allow anyone that hasn't followed that step to basically, operate and work for their business. Now, the purpose of these requirements is basically the city wants to ensure that the city's cannabis program and cannabis operations are filled with reputable individuals without certain criminal backgrounds, to ensure there's no fraudulent, nefarious, and or criminal behavior, and that the permittee maintaining that register of employees or people otherwise related similarly furthers that. So, hey, the city can, or law enforcement, or basically anyone can say, hey, who do we have working for you right now? Let's go ahead and take a look. That serves kind of two purposes. One, to ensure that operators in the city are reputable, respectful, and up to par. And then secondly, that should there happen to be any kind of unfortunate criminal or other nefarious activity, The background check and that register provides a vital resource for any subsequent investigation that, hey, if something goes wrong, okay, let's take a look at who was employed, who we have all their information, et cetera, et cetera. And these are simple, straightforward requirements meant to ensure that the integrity of the cannabis business in the city and provides these kind of fail-safes should anything go wrong. And in this instance, which the city code enforcement officer is online today, that he'll speak to later about the specifics of this, but that's kind of what we have here. A security guard was employed without compliance with those two sections. And despite appellant's contentions, appellant has complied with these sections for its other employees numerous times. This kind of belies the claim that the appellant was confused or didn't understand the language in the municipal code, and hey, you guys are really just jamming me up on kind of this minor technicality. That's simply not the case. These are very, very important regulations that the city is very on top of. This is not the first time there was an issue with the security guard and whether or not he or she was properly registered and did a background check. So this is kind of I don't want to say a continued pattern in practice, but to say that this is kind of the first time and it's coming out of left field, simply isn't the case. The city made multiple efforts to gain compliance. Trust me, we want nothing more than to reach out to a cannabis operator, say, hey, we found something wrong, them to respond, hey, thank you so much, it's taken care of, won't happen again. That's kind of a perfect world. But when those requests and warnings go unheeded and they kind of decide to ignore it, the city really has no choice but to up its enforcement activity. Finally, I did want to just briefly hit on the fine amount. The city council passes the fine resolutions, which set the dollar amount as it pertains to each violation. I know it was attached in your staff report, and staff and the city council kind of painstakingly went through every possible violation and kind of allotted it under a certain category. That A3, which deals with the register of employees, was listed as a serious violation in the fine resolution, thus qualifying it for a $5,000 administrative citation fine upon the first violation. City staff has no discretion in issuing these fines, in that city staff can't say, hey, you violated that, but I'm going to take it easy on you, I'm going to take a break, here's it for 500, et cetera, et cetera. And so while I do recognize that there was an unfortunate typo in the administrative citation, there couldn't really be any true confusion because staff had no discretion kind of whatsoever, that it had to issue the citation for 5,000 if it was going to issue a citation. It did. And that's kind of what we have today before you. That kind of concludes my portion of tonight's presentation. I'm of course available for any questions, and I know Director Goodhart has the code enforcement staff on if the board has any questions on the specifics of the kind of the citation and what kind of went back and forth between city staff and the appellant. Thank you very much, Chair.
Thank you.
I'd like to present to you Code Compliance Officer Mitch, who will outline the details regarding this citation.
Thank you, Director Goodhart. Good evening, members of the board, city staff, and members of the public for joining us for tonight's hearing. My name is Mitch Navhan, and I'm a Code Compliance Officer with the City of Palm Springs. And as part of my assigned duties, I currently serve as the city's primary cannabis compliance officer. The events leading up to the issuance of citation AB 6001 are as follows. So on Wednesday, April 20th, 2022, I visited the cannabis dispensary and consumption lounge, OG Arabian Nights, to conduct a proactive cannabis compliance check. Upon arrival, it was noticed that the business did not have any on-site security personnel as required. There was no security guard on site. I met with the store manager, Yvette Flores, who stated that their security guard had a family emergency and had to leave to tend to it. She stated that they had been trying to get into contact with one of the other guards to come in to cover, but did not have an estimate of when security personnel would be back on site. I reminded Yvette that under both city and state regulations, dispensaries are required to have on-site security personnel at all times during hours of operation, and that the business would have to suspend operations and remove any unauthorized persons from the business premises until they got their security personnel back on site. I also informed Yvette that I would return the following day to conduct a follow-up and review the surveillance footage to gather additional details related to those observations. Then on Thursday, April 21st, 2022, I returned to OG Arabian Nights and met with the store manager, Yvette, again, and we reviewed the video surveillance footage that they had there on site from the previous day. So after reviewing the video surveillance footage, it was found that there was about a 45-minute period without any security on site, in which the business processed 2 transactions before my arrival. While reviewing the footage, I had asked Yvette some questions about their security personnel, and she had mentioned that one of their original security guards, who I was more familiar with, had recently resigned, and that they had recently hired 2 new security guards. So while continuing to discuss the security personnel, Yvette did provide me with scanned copies via email. I believe those are included in the staff report, of Antonio and Alan's security license information. So at that time, I had advised that I would review the information received with the Department of Special Program Compliance office staff, and then I would reach out if I had any additional questions. So I immediately returned to the office and met with Michael Milan, who serves as the account clerk that handles most of the administrative side for the city's cannabis applicants and licensees, to discuss my findings related to their security personnel and review the most recent information we had from the business related to their employee roster. It was at that time that it was found that we had not received any notification from the business of the separation of one of their existing guards, who turned out to be Gina, and the addition of the 2 newer guards, Antonio and Alan. So I then drafted the email requesting the information, which is included in the staff report. I believe it's attachment 9. That's on page 68. That was sent on Thursday afternoon at 1:20 p.m., requesting an as soon as possible response with a deadline of the following day, which was Friday, April 22nd, end of business at the very latest. So this deadline was not met. And when I returned to work on Monday morning, I still not received a response back. And then it was at that point that I drafted a second email, which included the previous request to the store manager and addressed it to the business owners, Dr. Wen and Ms. Yang, advising the requirements and the information requested, as well as a last and final deadline to have the information provided to me by the end of business that day. On Wednesday morning, April 27th, when I came into work, I still hadn't received the information as requested. It was determined then that the business was in violation of the city's cannabis ordinance via the mentioned sections, and citation AB 6001 was issued and delivered to the business that day. It should be noted that the information was finally received in its requested form on Thursday, April 28th at 1:11 p.m. And then at that time, after reviewing the employee roster, it was found that the 2 most recently hired security guards, Antonio and Alan, had not had their live scan fingerprinting results returned clear with the police department, thus making them ineligible to have begun working at all at the dispensary and consumption lounge. So I know that was a lot, but that's all I have to present. I'll kick it back over to Director Goodhart, and I'm available if the board has any additional questions or follow-up. Thank you.
I did want to point out lastly that we did adopt an administrative regulation in September 2021 that allows our code compliance to issue citations without issuing a pre-citation warning or courtesy notice. The intent was to have strict enforcement similar to vacation rentals to ensure compliance with this business as it is of such a serious nature for the city. At this time, I will hand the meeting back to Monique to conduct.
Anything further from the city? Director Goodhart, anything further from the city? You're muted.
No.
Thank you. At this time, I will open it up to the board members to ask questions of the city. If the board members don't mind, I'd actually like to go first on this one. Officer Nabhan Khan, sorry. Is it standard procedure that people typically get you the information you've requested in a much more timely fashion within a day or less than a day? Is that pretty standard?
Yeah, it is. It's actually written in the operating requirements, and it's mentioned in an email that I had dated to Yvette in January 27th. But Section 555-200A6 requires that any cannabis licensee has to provide records within 24 hours upon request of the city manager or his or her designated appointee. And most of the times, you know, I'm pretty lenient when I'm requesting specific information, because a lot of times the documents that I'm asking to have take some time to reconcile and compile and get sent over to me. So I usually do give a couple of days. In this particular instance, I stuck more along the lines of the more restrictive 24-hour period, because like I said, there was information to lead me to believe that the folks that were serving in the security capacity had not been cleared through the properly channels and may have been technically ineligible to work. So that's why I stuck to a more restrictive timeline. And even with that, again, you know, there was a 5-day period before I took additional action and actually went forward with the citation to still give them that leniency.
And one more question is, in previous interactions with this particular business, have they been meeting those requirements?
So my initial inspection, which occurred in January, the end of January of this year, I had at the bottom there, in addition to the violations that we had identified that needed correction, I had put that I needed a response with an updated employee roster. That wasn't provided to me until March 4th. So that was in excess of the 24 hours. I've been to OG Arabian Nights, you know, approximately 3 or 4 times since then. And I have had communication with Yvette and kind of stressed the importance of, hey, if we're requesting stuff, you know, do your best to kind of get on this and get that over to us. So yeah, I've met with Yvette probably 4 or 5 times. The previous code officer, Officer Gomez, who had the interactions related to the same security personnel issue back in June of 2021. There was also some delay in some information.
I'm sorry to interrupt you. Can we get whoever's on that iPhone muted? Thank you. I'm sorry. Continue, please.
So, and that's part of the reason why there was so many attachments, was to demonstrate that this wasn't one-off behavior of failure to respond quickly. It's kind of been demonstrated that we've had 4 or 5 different instances where you know, information getting over to us has either not come or has come greatly delayed from when we had requested it.
All right, thank you. Other board members, Mr. Hedrick, any questions?
No questions at this time. Thank you.
Mr. Sinclair,
Nothing here.
Mr. Moses,
No questions at this time.
thank you. Mr. Basili.
No questions.
All right, at this time, we'll open the public portion of the hearing. If the appellant would like to present their case, you have 10 minutes. If there's any members of the public that wish to speak, the appellant will be provided a rebuttal time of an additional 2 minutes. Any members of the public that wish to speak will also only be given 2 minutes to speak. And then we'll open it up to board members for questions of the appellant. At this time, if the appellant would like to start presenting their case, and the 10 minutes will start now.
Yeah, this is Wen. We yield to our operational manager and store manager, Stacy Yan and Yvette, and also Steve Rosenberg will speak on our behalf. He has studied the city code greatly. Stephen, would you start?
My name is Steve Rosenberg, and I was the person who, at Mr. Wen's request, prepared the letter that was sent to the board yesterday evening. The rest of that letter was multifold. It mentions that the staff included all kinds of information that were not relevant to the 2 alleged violations. In particular, it was never stated that the appellant was confused. it was never stated that there was any misunderstanding or lack of information provided. When we heard that statement earlier tonight from Mr. Donegan, that was out of whole cloth. We never said that. And I would stand by the assertion that there's a lot of stuff in this 73-page package that has absolutely nothing to do with the alleged violations. In particular, let's talk about those two alleged violations. Oh, and by the way, before we get into that, since when does staff make administrative rulings to waive courtesy notices? That sounds like a function that's way beyond what staff ought to be exercising. It's either a city policy or it's not, but staff, I don't think, is the appropriate time or place to make those kind of policies. Regardless, the two alleged violations concern one thing: the register of employees.
You gonna go to that call?
Yeah, this is a weird one.
You know what? People need to be muted to stop interrupting. Go ahead, sir. Sorry about that.
That's okay. I was saying that the two alleged violations have something to do with providing a roster. In particular, section 5.55.200A21 is quoted as saying, any new supervisors, employees, or other persons engaged in the operation of an adult use cannabis business must submit their information to the city manager. Let's stop right there. This is a requirement for the employee to submit information to the city. The employer is not mentioned in this entire paragraph, and therefore the employer can't be charged with violating something the employee is supposed to be doing. So on its face, I think that this particular violation, alleged violation, is completely invalid. And I just will read the sentence again with emphasis. Any new employee must submit their information to the city manager. So it's clearly the employee that is responsible for this. Therefore, the appellant can't be found guilty of a violation here. Okay, coming back to section 5.55.200A3, the permittee shall maintain a current register of names. If you read through the, sorry? Hello?
Please continue, Mr. Rosenberg.
Yeah, we're waiting on you.
Okay, I'm sorry. I heard something in the background. This section says that the permittee shall maintain a current register of the names. And that register shall be provided to the city manager upon a reasonable request. Now, I want to emphasize upon a reasonable request. The appellant offered to print a copy of that register while the code enforcement officer was on the premises, but was told that was not necessary. Later that same day, the code enforcement officer sends an email saying, hey, I've got to have this by the end of the day. The employee responsible for responding to this had already left for the day, and therefore it didn't occur. The next day, which was his alleged deadline, was a Friday. The city wasn't even open. So how in the world, was the appellant supposed to respond to an employee who wasn't there and wouldn't be there for 3 days? I want to point out that in other sections of this very massive information dump in the city, they talk about a 24-hour deadline. And they cite paragraph 5.55.200, paragraph 6. And this is cited in an email that the code enforcement officer sent to the appellant. The paragraph states that each adult use cannabis business shall allow the city of Palm Springs officials to have access to the business's books, records, accounts for the purpose of conducting an audit or examination. This is neither an audit nor an examination. It's a request for information. So this paragraph doesn't apply here because it wasn't for those purposes. This paragraph does indeed say 24 hours upon receipt of notice, but it wasn't applicable to the situation at hand. So once again, they try to bring up a whole deluge of information from prior events, which is incomplete and incoherent, to be frank. That the appellant was, did this or did that or did something else. We're only concerned with the two things that they are alleged to have done here. And as I pointed out, one of them doesn't apply to the appellant at all, and the other one applies on a reasonable request. The appellant did respond in a reasonable manner to that request. I think that the fact of the matter is that the testimony so far this evening indicates that the code compliance officers have been to this business approximately, if I added up the numbers correctly as they were being spoken, 8 times. 8 times about a register? I would call this harassment, to be blunt. And they are known throughout the city for other cannabis operators to be very persistent in their inspections and work. This is just simply not done for any other kind of business. There is no need for this level of scrutiny. What we're talking about here ultimately is nothing but a paperwork violation, if in fact it occurred. And we dispute that occurred, but it's only a paperwork violation. The summons that was given to the appellant has 2 different fine amounts. And that was just dismissed in testimony as, oh, that's a typo. Well, it's a hell of a typo when you give someone a complaint that is incorrect. It has 2 different figures. It says that it's per count when there's 2 counts. It's totally, it's legally insufficient. And there's no question that that kind of information could easily be misconstrued. I'd like to point out that there is one tiny error in the written testimony I provided. I mentioned that all 3 of the appellant's employees were not native English speakers, and that's actually incorrect. One of the appellant employees is in fact a native English speaker. But I think that the density of the city regulation and the piling on of dozens of pages of information that unfortunately have nothing to do with the issue at hand creates confusion and intimidates the appellant. I would be happy to answer any specific questions that that either staff or the board have, but I do want to simply add one thing for the public record. I was involved in helping the city formulate some of its rules and regulations. I was involved with city council in helping to establish what we felt was a good framework. I think that unfortunately it's gone way too far. And I think this is only one example where we're seeing it again, 73 pages because they didn't produce a register in a timely fashion. And they didn't do something that the employee was supposed to do. This is nonsense. This is not how Palm Springs is supposed to operate.
All right, thank you. We're gonna now, is the time for board members to ask questions of the appellant. Mr. Moses, you have your hand up. Do you have a question for the appellant?
Yeah, I have 2, please.
Great, go ahead.
One is, do I understand from what you said that the employer is not responsible if an employee fails to do what's proper?
No, that's not what I said. I said what the employer is cited with is a requirement for the employee. And therefore you can't cite him for the employee not doing what they're supposed to. It's frankly, this is poorly worded because the requirement should be on the employer, but it's not. The plain language says the employee must do this. And they're citing Mr. Nguyen and his business for failing to do what an employee was supposed to do prior to employment. Okay, so, not as an employee, but prior to employment.
And second question, sir, have there been previous guards that were hired by the company where the requirements of this act have been properly met?
I cannot directly address that, but I am not aware of any prior failure on the part of the appellant to provide that information to the city.
No employee
Not aware.
work at the shop if they do not have live scan first.
I'm sorry, I didn't understand that.
No employees are allowed to work at OG Arabian Nights if they do not get live scan first.
Okay, and this person was still working, was he not?
All the ones that work at our shop has to be live scan first, or they will not be hired.
What the city is alleging here is that the city, were not notified in a timely fashion prior to the beginning of employment of the employee's status. That status was never in question. This employee was live scanned and indeed was qualified to work. He also possessed a state guard card, as it's commonly called. And the only issue is they're claiming that they didn't provide this information to the city 10 days before employment. That's not what the paragraph says. So even if we interpret that paragraph as to be an employer responsibility, it says the information will be provided within 10 days prior to the new employment. Within 10 days doesn't mean at least 10 days, more than 10 days. In fact, quite the opposite. It means that you can't provide that information until 10 days before employment starts. It doesn't set a deadline, so you literally could have provided that information 1 minute before employment starts, and you've met the plain language of the code.
But in this case, it was not submitted at all until after the notice. Is that not right?
That is not correct, sir. It was submitted.
Before the
Along with the guard card, you'll find in your packet there are copies of the correspondence, including the guard card and I believe one other document. But that was before the violation was, the citation was issued.
Anything further, Mr. Moses?
No, I think I understand what I've read in here. I understand what he's saying. So
Thank you.
for the
Thank
time,
Mr. Hedrick, any questions for the appellant?
sorry.
Just so that I'm clear, Mr. Rosenberg, you're stating that the two new employees were met all the requirements to be a guard prior to being officially hired, correct?
That is correct. And if you'll note, the appellant is not charged with having unqualified employees there. They're only charged with not having produced a register of their employees in an appropriate amount of time, according to the code enforcement officer. But the fact of the matter is the timeframes that he cites are incorrect, and I've pointed this out in my written testimony.
And the second issue is that they were operating without a guard present, correct?
That is an allegation that was made tonight in oral testimony. That is not part of the complaint.
Okay, I have nothing more at this moment. Thank you.
Thank you. Mr. Sinclair?
Mr. Chair, is this the time for me to ask the attorney a question, or the city attorney?
Why don't we ask questions of the appellant first, and then we'll circle back around if you have any
Okay, well,
questions for the city attorney.
All right, I reserve my right after he speaks to ask further questions.
All right, thank you. Mr. Basili? You're muted.
Sorry, no questions.
All right, Mr. Sinclair, why don't you go ahead with your question?
I was just going to ask Mr. Donegan what his take is on the appellant attorney take on the reading of the code, and whether he presented a nice synopsis of why there was a violation. Does the appellant's attorney change your mind on that, or is there something I'm not getting?
Mr. Sinclair, no, not at all. The city's interpretation is diametrically opposite to what Mr. Rosenberg said, and I can kind of point to the code language and then kind of give some backup kind of reasoning for that. So as an initial matter, the operative provision is not one of the 1 through, let me see how many there are here, 27 requirements. Rather, it's found in A, and it says each permittee shall not violate this chapter and shall comply with all of the following. The permittee, i.e., is the business who is granted or requests and applies for the adult use cannabis permit. Now, once again, going back to the language of the specific subsection 21, it says it does say that an employee or other person engaged, they must submit their information to the city manager. The reason being for that is that the city determines whether or not someone passes a background check, whether or not they're qualified to operate. Further, we did not want to enmesh and kind of integrate cannabis owners in that process, i.e., if I want to show up and apply and work at Mr. Wen's facility, that background check, that live scan, that is better done through official government channels where we have legal requirements to keep that information private and safe, rather than those employees basically submitting their whole background, their fingerprints, whatever that process may be, to the employer, and then the employer making that kind of determination itself. And so, you know, I understand Mr. Rosenberg is kind of, you know, grasping here and saying, hey, look at 21. It doesn't say the business owner. It doesn't say, you know, Mr. Wen. It doesn't say the business operator. But inherent and pregnant in that is saying that you must do this before your employment. Who does the employment if not the employer? You know, I can't just show up to Mr. Wen's shop and say, hey, I'm here to work. I'm going to be your employee now. That strange reading of section 21 is not something that the city staff agrees with, and to be honest, I think it is incorrect, sir.
Let me ask if I'm allowed, Mr. Nabin, Mitch. Did any security guard employee ever submit anything, his or herself, to the city and to compliance?
So previously we had information related to 2 security guards that was conducted on follow-up investigations by the previous code officer that was handling cannabis compliance matters. And that was Ms. Gina Ayala and Mr. Limberth Estrada. And they were both listed on the employee roster that was submitted by the store manager, Yvette Flores, on March 4th in response to my request that was made on the January 27th of this year.
So no employee guard that you know of ever submitted information directly to the city for their employment? The person themselves, it was always the employer who submitted the information?
Correct. So the general process with most operators is that if there's an offer of employment, they then provide their that individual with the live scan form that has the pre-filled routing on there that directs it to the police department for when if they do it outside, if they get fingerprinted outside of the police department, if they go to a third-party live scan facility, that sheet is generally provided by the employer upon conditional offer of an employment, pending the results of that.
So it always comes from the employer in the end.
In the operations that I'm familiar with, that's generally the practice. I can't speak specifically to OG Arabian Nights hiring practices, but that seems to be what the most of the process is.
Thank you.
So I have a question for Mr. Rosenberg. I'm a little confused by your argument. You had said that this was the first you had heard of that, that maybe there was some language barriers, but in your written testimony to us, you brought that issue up. You talked about how you were involved in writing these regulations. However, you also described it as the wild, wild west. So frankly, I'm a little confused as to, what your position is. Is your position is that this was just a paperwork violation and therefore doesn't warrant this? Mr. Rosenberg? And if you are speaking, you are muted.
Stephen, are you there? Stacy, would you speak up?
I'm sorry, I believe the question was addressing to Mr. Rosenberg's early participation with the city. I don't know if I can speak on his behalf.
All right,
But
thank you. I withdraw the question. So, all right, at this point, we're going to close the public. Is there any members of the public? Mr. Hedrick, did you ever?
Well, that's what I was going to suggest to you. We haven't had any public response.
Okay. Is there any, City Clerk, is there any members of the public who wish to speak on this case?
I have no registered speakers. However, if someone would like to provide comments, please use your reaction button on the bottom of your screen to raise your hand.
I saw one hand, Mr. Pentel or Pentelli. I'm not sure if I'm saying your name correctly. You would have 2 minutes to speak, and then the appellant will have a moment to rebut your testimony. Go ahead, please.
Okay, thank you. Mr. Rosenberg is having issues, I'm pretty sure, with how to use the mute and unmute on his phone. He is a little technically challenged, but I'm pretty sure that the answer to your question would have been the latter of the two that you had asked, that he is just thinking that this was the paperwork dispute and not more. I don't believe it was beyond that, okay? And also, just because I helped Philip, Dr. Wen get his permit, I can tell you that I don't help people get permits, and I don't operate with people in this town unless they follow the rules and do the right thing. So as a reference on my behalf, as someone who has helped get many permittees licensed in the city of Palm Springs, I find that OG Arabian Nights is doing a really good job. And I'm not going to get into whether or not they broke the rules. I think Mr. Rosenberg set the case out for them. I believe that this is overkill for the type of, I believe that we can handle things better like this in the future without getting this many people, this much money together with a little better communication. So I'll leave it with that. Thank you.
Thank you. And is there any other members of the public that
We
wish
have-
to
I
speak?
do see a member,
Okay.
Anto. If you can unmute yourself and state your name. Anto? Hello, Anto, if you can hear us. If you'd like to speak, please begin now. Chair Panessa, I'm not seeing any activity.
All
And
right.
that concludes.
Thank you. We're going to move on. So at this time, we'll close the public
Actually-
portion. I'm
I'm
sorry.
sorry, I do see that Flores raising her hand.
Okay.
Good afternoon. This is Eva Flores. So I'm not sure who this question would go for, but there was brought up about the life scan. So an employee has to take a life scan 10 days before they are hired. But I have gotten life scan emails like a month to 2 months after that the employee was approved. So if the employee isn't approved in the timely manner on your end, do we just stop operations?
Who are you directing that question to?
I am not sure who would be able to answer that question, whether it's Mitch or
Director Goodhart,
Paunosa.
could you respond to that, please?
Our code is clear that every employee must undergo a life scan, and those results must be received prior to commencement of their employment. If a business has multiple employees, they need to ensure that all of them are cleared prior to the commence operations. Unfortunately, we have a very large thriving cannabis industry that at times does cause a backlog in the review and approval of these live scans, but we cannot waive that requirement. We've had applicants who were disqualified based on felony charges where they were not eligible to work at a cannabis business. This is for the protection of the business and the public. So whether or not a business has to halt their operations is on, a determination has to be made by them. This is also, they had more than one security officer. So if they had more than one security officer, they could have alternatively used the other while the background was pending, or they could have hired a contractor to come in and provide temporary services to maintain their operations. This is nothing new for this business. In June of 2021, we determined that they had no security officer present and had been operating since November 2020. It is both state and local law that they have to have a security officer present during operations. This should have been communicated to them by their consultants. I mean, it's a pretty standard requirement.
Thank you. All right. If there is no one else that wishes to speak from the public, we are going to move on.
Yes, sorry. I also have one more thing to mention, that the day that Mitchell Naban did come into the store and I sent him the 2 guards, I also offered him the employee roster, and he says it's okay until I received that email a few hours later asking me to give him the employee roster. So it was offered in person as well, but unfortunately I was already clocked out by the time he needed it.
All right. So, and I think he testified, excuse me, that it took 8 days. So you want to respond to that?
Yes, it did take 8 days, but he was also offered the day of in person.
I understand that, but it then took you 8 days to send it. Is that correct?
So after that Thursday, I was off for 4 days, and then he came in to cite the citation, but I don't believe it was 8 days, actually. I have to go back right now.
Thank you. All right. Unless there's anyone
Sure.
else. Yes, ma'am.
I'm sorry to interrupt. I'd just like
That's
to
all right.
draw your attention to the public comment in the chat box. I just gave you access to it. Apparently the person has mic trouble, but they wanted
Okay.
you to be aware of their.
Let me click on it here and we'll see. I'm not seeing any messages in there.
Would you like me to read it for you?
Please.
It just says, I wanted to provide the following feedback. This is a matter of public safety. As a resident of Palm Springs, I want to know that when I visit my local dispensary, proper protocol is being followed to ensure a safe and reliable experience for the public. With recent burglaries and vandalism occurring across multiple dispensaries in Palm Springs and greater violence across the country, this violation by Arabian Nights in effect have put the public in danger. Not having a properly vetted security guard on premises who is in charge of public and business safety is unacceptable. If the board does not uphold the violation, why even have regulations in place if they are not going to be enforced? I urge the board members to uphold this fine against Arabian Nights for both violations of Code 5.55.200A3 and 5.55.221.
Thank you.
Second.
City Clerk, can you, for the record, tell us who that was from?
This person is listed as Anto.
Okay.
There's no last name.
All right, thank you. All right, so we are going to close the public portion of this hearing. It is now time for the board to discuss amongst ourselves the testimony from both sides. Why don't we start with Mr. Hedrick?
No questions. Thank you.
Any discussion points?
No, I think it's pretty clear. It's clear for me on how I'm going to vote.
All right, thank you. Mr. Moses, any discussion points?
Well, based on Mr. Hedrick, I won't, unless anybody wants to know why I feel how I feel, I've made up my mind.
Why don't you tell us how or why you feel how you feel?
I think no matter how you blur the situation, there is a requirement of the law which the appellant was aware of and didn't meet. I think the fine, it should be upheld.
All right, Mr. Basili.
I have no questions. I'm pretty clear on.
Any comments for discussion?
Well, it just falls back on, I heard the discussion that it was being pushed on the employee to be responsible for submitting documentation to the city. And I feel that we've gone through this with other avenues of discussion with short-term rentals and stuff. And ultimately, I feel that it's the employer who's responsible for making sure that his employee follows all regulations and rules in order to be compliant with the laws of the city. So that's just my comment. I felt that this was pretty clear after hearing everyone's take on the discussion and how they felt who was responsible. I think it's pretty clear that the employer is ultimately responsible for the employee.
Thank you. Mr. Sinclair, any discussion points?
Yeah, I would agree. I think we've had, on the part of the appellant, I think we've had an attempt to obfuscate things. And I think that Mr. Gonigan's reasoning is sound.
All right, I guess I would agree with Mr. Sinclair, and I think he put it very well. I felt like that there was lots thrown at us, whether it was, claiming that the appellant's English isn't their first language, and then saying they were surprised by that. He helped write the regulations, but then think they go too far. I would agree with Mr. Basili that I think the onus is on the business owner to make sure they're in compliance, and to push that off on the employees, I think is completely inappropriate. And also I would add, from my perspective, is that this is not like any other business. This is a highly regulated business, both at the state and the local level, for a reason. And so I don't buy the argument that this is going way too far. And with those comments, I would ask a board member to make a motion and a second.
I move that we would uphold the citation and the fine.
I second.
Thank you. City Clerk, can you call the vote, please?
Board Member Moses,
Aye.
Board Member Basili,
Aye.
Board Member Hedrick,
Aye.
Board Member Sinclair,
Aye.
Chair Panessa.
Aye.
Motion carries 5-0 to uphold.
All right. Thank you, everybody, for your time and effort on this case. This was our first cannabis-related case, and so we had a lot to learn, but I appreciate everyone's effort. We are now going to move on to our next case, which would be number 3 on the agenda.
Mr. Chair, could I have a 3-minute stretch?
Certainly. We will be back. My clock says 6:41. Please be back and ready at 6:44.
Perfect. Thank you.
That's very specific. Oh, no. No barking. No barking.
From within the condo community indicating that Unit 106 at 2822 North Auburn Court in the Palm Springs Villas 2 development was operating an unpermitted vacation rental and included a link to the advertisement. It should be noted that vacation rentals are not permitted in this HOA community. And we've had a very good working relationship with this HOA over the last 5 years because they have not been allowed and they send them to us all the time. The advertisement number is 32554048 and was located on Airbnb. The advertisement is titled Vacation Getaway Close to Downtown and Restaurants. It lists the property as a 1-bedroom condominium with 2 beds and sleeps 4 guests. This is item 3-24 in your packet. The property has 62 reviews from guests. On October 6, 2021 at 7:38 a.m., I sent a booking request to the property host Parvi, asking if the property was available November 17th to November 21st. A personalized response was received from the property host Parvi at 11:15 p.m. that same day, stating, "Hello, Dave, the dates you requested are available. I will also provide you with check-in details before your arrival." Parvi then sent an automated booking invitation. This is item -3-34 in your packet. At that time, I issued citation AB0356 for operating a vacation rental without the proper vacation rental certificate. That concludes my presentation, and I am available for any questions the board may have.
All right, anything further from the city?
Nothing further, Chair. Thank you.
Thank you. Mr. Hedrick, any questions for the city?
No, thank you.
Mr. Moses, and you're muted. Shake your head no if you have no questions. Thank you.
Hello, sir.
Yes,
Okay, I'm talking on behalf of Parvin and Oscar Sohaili. I'm their.
it is not your time yet. I will
Okay.
tell you when it's your time. Thank you. Mr. Sinclair, any questions?
No questions.
And Vice Chair Kane? No, and Mr. Basili?
No questions.
Thank you. I guess I don't have any questions either. All right, so we will now move to the public hearing portion of this. The appellant will have 10 minutes to speak. If any member of the public wishes to testify, they will have 2 minutes, and then the appellant will have a 2-minute chance to rebut any public testimony. So the appellant, your 10 minutes starts now. This is your time now. Go ahead.
Well, okay, would that be me? Sorry.
Yes. Please
Okay,
state your name so we know who's talking.
Okay, my name is Jay Sohaili. I'm talking on behalf of my parents, Parvin Shiravi and Oscar Sohaili. And their English is not that well, so I'm just gonna be speaking on behalf of them.
Okay.
I'm also managing their short-term rentals and doing long-terms more than 28 days. The thing is where they live in Laguna Hills. And I have one question. As far as I know we received their first mail in a letter saying that we receive usually all the letters to the 2822 North Auburn Court, but we hardly check the mail there. But this mail was like a surprise to us when we first received. But on the first citation, is it usually $5,000 when you receive it, or do they give you like a warning? And then, or is like, I'm just trying to say, is that the first violation you should get? Is it $5,000 for short-term rentals, or normally do they give you like a couple of notices in mail, and then if you don't cooperate, then they violate you?
Patrick, I'll let you speak to that, please.
Yes, and thank you for the question. Yes, with the city of Palm Springs, the first violation for operating without a vacation rental certificate is $5,000, including a permanent ineligibility to operate a vacation rental further in the city. And then also regarding maybe warning letters that may be sent out, we do have an administrative regulation that was created in the city talking about the issuance of citations, and that there would be no courtesy warnings given regarding that, and then
Okay.
citations will be issued. And that is on our website available. It's an administrative regulation dated October 2018, and it's actually titled Authority for Issuance of Administrative Citations.
Okay, so my other question is like, when we didn't know too much about short-term rentals because we were doing long terms. I know over 28 days is considered normally a long-term rental, right? And you don't need a TOT, or I guess it's a permit. I'm not too familiar with these things. But anyhow, when we were doing short terms, and through Airbnb platform, they have like this tax that you're supposed to report. It's like a W-9 or a 1099-K. We thought that that's the tax we're supposed to have, or, to report, in other words. But I don't know really anything about the TOT till I did more research. And then I realized, also, I guess we had to go through the HOA. That's another thing, right? The HOAs usually don't allow you to either do more than like 28 days or 30 days. You have to get an approval through them. But speaking on behalf, they were really not aware of like what they had to actually do. And this was all like a surprise for us. And, we got violated, but I don't know what we can do. I mean, we just thought we just have to report the 1099 through Airbnb again. And that would, basically report like a tax that we have to pay, or, to the IRS. I really didn't know what to do at this point on behalf of them. So I don't know. We would love to, like, one of our questions, we don't know if we're allowed to do short-term rental in the Villa 2 community. And two is if we even with a permit, of course, you guys are saying without the permit, you cannot operate a short-term rental, but with a permit, we don't know if even the HOA allows it or not. But, we never asked, but they were not trying to break any rules or anything. They're just really not aware of like what they're doing. And I was helping at the same time, manage it. So it was all a surprise for us, when we got the letter. And my other question is, are we allowed to rent more than 28 days?
So we'll cross that bridge depending on how the appeals board votes to uphold or overturn the fine. But speak for the department that without a permit, it is a minimum of 28 days. And Patrick, correct me if I'm wrong.
Yeah, short-term rental in City of Palm Springs, 28 days or less. If you're doing rentals 29 days or more, that's not under our jurisdiction to monitor. Yeah.
Okay, perfect. So that's what I didn't know. And that's what we're doing now. We're not doing any more short terms right now, but everybody's more than 28 days. And the other question is if we're allowed to, get the permit. I mean, obviously it says we're banned from it now, obviously, because we got this violation. Do we have to get permission through the HOA? Is that how the process works? I don't really know how the procedure.
That would be between you and your HOA.
Okay. So are we going to be banned permanently, or can we like backdate all the TOT?
We haven't voted yet, so
we haven't.
We can't answer that.
All right. That's the end of my conversation. Again, I just want to say we were not aware. We thought we had to go report all the, things.
Let me answer your question slightly differently. You cannot do anything the HOA does not allow. If the HOA allows it, you must get a permit from the city.
Got it. Okay.
All right. Thank you.
Thank
is
you,
anything further, Jay?
No, that's all. Thank you, sir.
All right. Thank you. Is there any member of the public that wishes to speak on this case?
Chair Panessa, I see no hands and I have no registered speakers, but if anyone is present and would like to speak, please use the reactions button on the bottom of your screen to raise your hand. I see none.
All right, thank you. All right, at this time, does the city have any rebuttal to the appellant's testimony?
Nothing further, Chair. Thank you.
Thank you. All right, this time, then we will close the the public hearing portion of this. And at this time, for the board to discuss amongst ourselves the testimony that we have heard from both sides. Why don't we start with Mr. Basili?
I think this is a situation that we've discussed many times over and over again. The thing I have, the appellant mentioned one thing that kind of threw me off, and that was he's managed short-term rentals for his family already. So is he not getting permits for those rentals as well? I can't imagine any town that's allowing short-term rentals, they're not requiring people to get permits in order to operate them. The other thing is if they've been operating and he's relying on Airbnb, as he mentioned, to pay a tax, then he's not paying the city tax and for having the opportunity to rent this property short-term. So I heard the whole story and it's very clear, and it's a situation that we've gone over and we've heard many times over and over again. Unfortunately, there's no excuse for not getting a permit and not registering your short-term rental. So I think that's all I wanted to say.
Thank you. Mr. Sinclair?
I have nothing more other than a question that may be for later. When we have these situations, do we ever try to recoup the tot? Patrick,
That would be a question for Patrick.
do we ever recoup?
There is a process for us to do that. Part of the penalty is that a determination is made where we will see how much approximate transient occupancy tax is owed to the city, and as far as penalties for each year that a certificate was needed for years of operation. So that determination is used by the evidence that we have as far as the advertisements found, and then a dollar amount, I believe, is created and then communicated to the site, the person cited for payment to the city.
Thank you.
That works with the finance department as well, determining how much tax is owed.
Thank you. Mr. Moses?
The entire defense was mea culpa. No, don't have any questions.
Vice Chair Kane, any comments?
No, this is unfortunate, but it is what it is.
Thank you. Mr. Hedrick?
No additional comments. Everything. It's all
So
well
just
said.
From my perspective is when there are 62 reviews, it's been rented quite a bit short-term. Maybe some of those don't meet the definition short-term, but it certainly was rented quite a bit. And when the HOA doesn't allow for short terms, in my mind, that is kind of a pretty significant negligence on the part of the homeowner, regardless of which one of the family members was managing it. Is one of the board members want to, go ahead, Mr. Hedrick.
I'd just like to ask the person, do they have other vacation rentals in Palm Springs?
No, we don't. That's the only one. And also, I replying to the other question. I answered one of the. I don't know who said this, but that we will be reporting the 1099 and the 10. It's the 1099 W9. We will be reporting it. I know he said that we were not going to be reporting it, but we are. We're definitely going to be reporting it. How much income we made.
So just to be clear, I think the question was, the city collects a 12.5% tax on short-term rentals. So regardless of what you do in a 1099 with the state or federal government, there is back taxes that are probably owed to the city. The city, like I said, has a 12.5% tax for short-term rentals. And so it sounds like that was not taken care of either.
No, we didn't know anything about because we obviously didn't get the permit, so we didn't know how much back taxes we have to pay.
So, all right, at this point, if a member of the appeals board would make a motion and then I have a second.
I move we uphold the decision of the city and the permanent ban and the fine.
Do we have a second?
Second.
Thank you. City Clerk, can you call the roll, please?
Board Member Moses,
Aye.
Board Member Sinclair,
Aye.
Board Member Basili,
Aye.
Vice Chair Kane,
Aye.
Chair Panessa.
Aye.
Motion carries 5-0 to adopt the resolution upholding the decision.
Thank you. Again, thank you, everybody, for your effort on this. To the appellant, what this means is that you are permanently banned from getting a short-term rental permit in the city of Palm Springs. You are able to rent long-term, but short-term rentals are now prohibited for you. And the city will be reaching out to you in a more official capacity about the fine and the ban. Thank you, everybody. We are going to move on to our last case, which is number 4 on the agenda. That is the appeal of the administrative decision that Kimberly Keys and Kenneth Rosenfeld are permanently ineligible to operate a vacation rental in the city of Palm Springs, and the administrative fine of $5,000 for operating an unregistered vacation rental property located at 2965 East Avery Drive, Unit F in Palm Springs, California. City Clerk, can you please ensure that the city staff and the appellant understand that their testimony is under oath?
City staff, appellants, and any other individual who desires to testify under this appeal hearing under the laws of perjury, if you choose to speak, you hereby accept and acknowledge that your testimony shall be the truth, the whole truth, and nothing but the truth. Please begin your testimony by stating your name.
Thank you. At this time, I'd ask for the city report.
Yes, good evening, Chair, Vice Chair, board members, city staff, residents on the call this evening. My name is Patrick Clifford with the Department of Special Program Compliance, and where we oversee the vacation rental program here in the city of Palm Springs. Before you this evening is a staff report regarding the property located at 2965 East Avery Drive, Unit F here in Palm Springs. It was determined that the owners have, without a registration certificate, advertised and operated the property located at 2965 East Avery Drive, Unit F, as a vacation rental from the elements that are shown in the staff report, page 2, and investigated by the code compliance officer. With the findings from the code compliance officer, a citation, it was issued January 13th, 2022. The code officer that did conduct the investigation is on the call this evening, and I would like to invite Officer Williams to further provide testimony. Thank you.
Good evening, Chair and board members. My name is David Williams. On December 21st, 2021, a message was sent through the Department of Special Program Compliance website that stated the property located at 2965 East Avery Drive, Unit F, was advertising and being booked for less than 14 days, and states that one recent review was for 2 weeks in January. A link to the advertisement was also included on the online complaint form. The advertisement number is 530-68898. That is item 4-53 in your packet. The advertisement lists the property as an entire condo/townhouse with 2 bedrooms and accommodates up to 4 guests. It offers self check-in through a keyless entry pad. The property had 1 review and is hosted by Tea Time and co-hosted by Victoria. On December 22nd, 2021, I sent a booking inquiry to the host at 12:43 p.m. In the request, I wrote, "Hi, I wanted to see if your home is available January 6th through January 10th, 2022. My husband and I will be heading to Palm Springs to visit family. Please let me know and I will book it." On December 23rd, 2021 at 7:19 a.m., the host sent a personalized response. "Yes, these dates are available. Feel free to book and let us know if you need anything else." That is item 4-36 in your packet. An automated invitation was also sent by the host. At that time, I issued citation AB0366 to the property owners for operating a vacation rental without the vacation rental certificate. That concludes my presentation, and I am available for any questions the board may have.
Thank you. Anything further from the city?
Nothing further, Chair. Thank you.
Thank you. At this time, this is reserved for board members to ask questions of the city. Why don't we start with Vice Chair King?
I don't have any questions for the city.
All right, thank you. Mr. Vasili,
No questions.
Mr. Sinclair,
No questions.
Mr. Moses,
No questions.
thank you. Mr. Hedrick.
No questions. Thank you.
I do have one. Mr. Williams, you had said that the person, I think the tip, if I understood that correctly, said that they were renting for less than 14 days. Is that the minimum at that complex?
I don't believe this condo association allows them because we don't have any registered at that, within that development.
Oh, okay. But the tip mentioned that, but that's kind of neither.
That
here nor
was the extent of it, yes.
All right, thank you very much. All right, thank you. We will now open the public portion of this hearing for the appellant to address this, and if there's any members of the public. The appellant will have 10 minutes to speak. If a member of the public chooses to testify, the appellant will be given an additional 2 minutes to respond. At this time, the appellants can go ahead and start.
Good evening, Chair. Good evening, members. Good evening, city staff. My name is Attorney Ron Irwin with the Irwin firm. I represent Kenneth Rosenfeld and Kimberly Keys in this matter before you this evening. Appreciate you taking the time, and I'd also like to take just a couple seconds of my time to compliment and thank the staff that had worked with me in helping me prepare for this meeting this evening. They were very professional, very kind, and very forthright. I also want to make it very clear that the owners of this property, Kimberly Keys and Kenneth Rosenfeld, did not at any point in time contemplate or operate a vacation rental in the city of Palm Springs. It was never their desire. It was never, in fact, it was their explicit instructions when trying to determine what else they can do with the property when they weren't occupying it. It was very clear that it would not be used for short-term rentals. And this is not just because of the operational concerns or the concerns with the ordinance. It's because it's their home. They didn't want strangers tramping through it. They didn't want to have to take care of the maintenance and organizations because their HOA didn't allow it. It's because it was not what it was purchased for. You have before you in your packets tonight a declaration from Mr. Akash Lal, who is the owner of Tea Time Properties in Sacramento. Akash Lal is also a friend and neighbor of Mr. Rosenfeld and Miss Keys. In discussing the purchase of property in Palm Springs, Mr. Rosenfeld and Miss Keys asked him as a professional property manager, what could we possibly do down the road in long-term rentals if and for those periods of time when we're not down there using the property? Mr. Lal said he would look into it. Mr. Lal assigned that to an employee. That employee took it upon himself, despite the explicit instructions from Mr. Lal, to post this on Airbnb. I heard it stated earlier, and by the way, I was quite impressed. I saw all the people in here. I wasn't sure if this was my hearing or if I'd walked into the Johnny Depp Amanda Heard hearing, but then I heard it was about cannabis, and I thought, okay, well, now I know why I'm so busy. But when I look at this, you know, I believe it was Mr. Baselli that says, we've heard this before about employee-employer relationships. This is not an employee-employer relationship. This is a vendor contract relationship. And it was violated, it was broken. And my clients were so far attenuated from that decision of that employee that it is unforeseeable for them to believe that their actions or that their orders and their explicit instructions would not have been carried out. The statute, the ordinance states any person, not the homeowners, any person in sub D of your code who operates a vacation rental without vacation registration certificate shall be liable. That would be Mr. Lal's employee or Mr. Lal if you want to apply a respondeat superior theory. I'm going to say also that the city staff identified one review. But from the dates that were provided to the city and in the report, there were 0 reviews at the time that your code enforcement officer outreached to Tea Time. Apparently, the one review was posted in January. The outreach was in December. Code enforcement officer didn't say anything about how he went to verify whether or not that was an actual stay or a review. Code enforcement officer didn't indicate how he verified that the posting on Airbnb had any relation to the property owners, or who Tea Time was, or what their business was. There was nothing here that ties it to Mr. Rosenfeld or Ms. Keys. There was one review. I don't know enough, forgive me, I don't know enough about Airbnb to know, but I do know with the great tantrum of fake news these days, I don't know if marketers are able to post reviews on Airbnb or not. But what I do know is that there was nothing in the report that said it was investigated. And I know that that one review came afterward. I also want to point out one of the benefits of going last, I guess, in an evening. You know, I listened to, and I know these are 2 different departments within the city, but I listened to the city attorney earlier tonight talk about how the city tries to be reasonable, not being draconian. The city staff or compliance officer in the first case tonight was talking about pre-citation courtesy notices. And that, you know, the city tries to give leniency in issues. And these are issues, as that one public member brought up, of public safety when we're talking about cannabis operations and security. And yet in your special programs, it was decided there would be no courtesy warnings. And clearly not enough investigation to really place this upon my clients. My clients did want to determine if they could do long-term rentals with this. And after the fiasco with Tea Time, as admitted to under oath by Mr. Law, my clients fired Mr. Law and his operation. And they started talking with property managers to determine what their possibilities were in Palm Springs. What they had come up with, what they're looking into at this point in time, what they're talking to their HOA about, is offering 30 to 90-day rentals to traveling nurses working in your area. It's a setup that allows for traveling nurses, and this fits what they want to do because they know when they're going to use their property. And they're looking the rest of the time to be able to use it to do better things in the community. Look, Mr. Rosenfeld and Ms. Keys are very vibrant members of communities across the state. They're important members of their community up in Sacramento. They enjoy Palm Springs. In fact, I'm on my way down there tonight as soon as this hearing is over. So, you know, these are people that like want to plug in. They're not looking to be a problem. This was not something that they intended. It's not something they wanted. There is no evidence that suggests otherwise. And the statute says any person, but it wasn't them. So when the city says that they were able to show that the owners have operated this as a short-term rental, there's just no evidence to suggest that. And I'll reserve any time I may for rebuttal.
Thank you. Is there any member of the public that wished to speak on this case?
Chair Panessa, I see no hands, but
Thank you.
as
All right, thank you. At this time, the time for the board to ask questions. Oh, I see a hand.
Yes.
SB,
Yes.
you have 2 minutes.
Okay. I sent in a letter today outlining my observations. I live adjacent to the unit in question. And I sent in a letter with my observations when I realized that there were people coming in and out of that unit on a regular basis. And I documented, I sent it into, I think I got a response from, was it Ms. Kane or was it, I'm sorry.
Probably was the city clerk.
The city clerk, yes, who emailed back and said that she had received the letter. If you have the letter there, you're welcome to read it. Well, anyway, I've documented people coming in and out of that unit since it was realized that was happening. I also want to say that per the homeowners associations CCRs, their guidelines, it specifically says that short-term rentals are prohibited. And there's a long list of people coming in and out. I happen to have, I don't want to think that I'm spying on people, but I have a Ring doorbell, and I'm able to, when I was made aware of this situation and when I noticed it myself, I started looking at the Ring doorbell to see, what was the motion? Were the people outside of my garage, or were the people coming in and out? And I've noticed at different times of the day or night that there were different people coming in and out and opening the garage through their through the code, through the code on the door. And so I also know that when they took the advertisement down from Airbnb, they put it up again on VRBO. So, it's not, they, as far as my knowledge is concerned, there has been no discussion. I attend the monthly meetings, and I have never heard a discussion about the owners wanting to use this as a long-term rental facility. And I also have never heard in any of our meetings that they were planning to rent this to traveling nurses on a long-term basis. So the arguments, as far as I'm concerned, that are being presented are untrue. And, I think just because of the fact that short-term rentals are prohibited in the CCNRs, it's a violation of our governing rules.
Thank you, Mr. Berger.
Thank you.
The appellant, if you would like to respond to that.
I would, Your Honor. I would. Forgive me, I was in court all day, Your Honor, Mr. Chair.
I am not Your Honor.
First, I believe that Mr. Berger went over the 2 minutes, so I'd ask for a little bit of leniency here to be able to address all of the issues that he brought up. First of all, he showed up on this as SB. I have no idea who he is. All I have is the claim that he's a neighbor who stated that he is violating my client's quiet enjoyment rights by tracking and documenting who comes in and out. There's a humongous difference between somebody that comes in or out of the building and somebody that is violating either the HOA or the city's rules regarding short-term rental and vacation. Okay. Secondly, this committee has no jurisdiction over the HOA or their CRCs. My clients have been called before the HOA board. They have tried to answer that board. There was a shift in management. And I can tell you that the discussions that had taken place regarding their desire to do long-term placement that he identified and mischaracterized as being untrue were had with me with their management company and who they hired to attend to and deal with these types of issues. And it just seems to be a really misplaced idea, certainly not something that we would be discussing with the neighbors as far as traveling nurses. As far as people coming in and out, again, the place was built, it was bought for my clients and their family and their friends, and it is not used as a short-term rental. There is no ad that I am aware of on BRBO or VRBO or whatever it was that Mr. Berger said. There is no evidence in this record that indicates that there is anything up on VRBO or BRBO. To my best knowledge and understanding, there isn't. And if there is, it would be taken down immediately as well, because it wouldn't have been placed by my clients. And that's another thing as well. There is, especially in what raises a concern with me, and it is a reasonable concern, is that you have somebody that doesn't like a neighbor. There is nothing that stops them from getting online and putting up an ad and saying, oh, look at this. I'm not suggesting, and I'm certainly not accusing Mr. Berger of doing that. But what I'm saying is that this is why in most tribunal situations, you have evidence, you conduct evidence, you investigate the situation. So I would ask that the entire committee disregard Mr. Berger's testimony and comments as just not being relevant or supported by any fact or evidence in this proceeding.
All right, thank you. If there's no other members of the public that wish to speak, we will now close the public portion, and this time is now for board members to ask questions of the appellant.
Am I allowed to, there was something I left out in my discussion. Can
I
I just-
apologize, but your time has ended, and
Okay.
so the appellant has already responded, so we're going to move on.
Okay.
Thank you. I guess I would like to start with, there is an ad in the city's packet. Let's see if I can get to the page, sorry. It's page, section 4, page 29. Is it your testimony that that ad is not for their condo?
That's not what I said. I said that ad was not placed by my clients.
But that
was not
is their
approved.
condo.
That ad
That's
was
not, that's, I didn't ask who placed it. I'm asking if that's their condo.
That is their condo. But if I may finish, they had no knowledge that it was posted. They gave explicit instructions not to post it. They gave them explicit instructions that they should not be posting anything on short-term rentals. Mr. Rosenfeld is an attorney. And as you can imagine, if I can speak with pure candor.
Sure.
The $5,000 is not going to drive them into bankruptcy. Okay. The denial of short-term rental status, they don't care about because it was never contemplated or intended to be a short-term rental. What's concerning here is the reputation that Mr. Rosenfeld and his wife acted in aversion to the law when they did their due diligence to make sure that they stayed within the regulations and the rules of the city. And that we make it a very clear record that there is a difference between an employer and employee. The second case you had tonight, the difference between the mother and father that own the property and the son that works for them managing the property, and a vendor contract or vendor customer relationship. And I believe that was extraordinarily set forth. I think it's very clear in the plain language of your ordinance that the city that wrote the the city members that wrote the ordinance and approved the ordinance saw that too, which is why they said by any person, not by the owners. But to answer your question, yes, that I believe now, let me clarify. I've never seen the inside of their condo. I've never been to their condo in Palm Springs, but I have no reason to believe that those aren't an accurate depiction.
Okay, the other question I have is, you had said that the review was after the citation. The citation was in December. The review was posted in November. I use Airbnb. I'm quite familiar with it. You cannot post a review unless you've had a reservation that has been filled, which means this person had to have stayed there to write this review.
Sure. And again, if I may, I didn't, Mr. Chair, I didn't say that they didn't stay there. I said I wasn't familiar enough with Airbnb to determine whether it was. If my dates were off, forgive me, but I believe that the contact by your code enforcement officer was in December and that the review was posted in January.
But the review was posted in November.
Oh, the
review that's in front of us says November 2021.
Then forgive me, my aging ears got that mixed up. But
okay,
either way, we're talking about one review that was not permitted by my clients.
All right, and I have one more question. Sure. So presumably, if they rented it, whether it was somebody else renting it on their behalf or not, they would have received income from that rental. Was there no question as to where that income came from?
No, I don't know that that's necessarily true, because I am not privy to, nor do I know that they had received any income, nor is there any evidence that they had. Had Mr. Lal, through Tea Time, published that ad, yes, there would have been a transaction, presumably. However, I will also say that there wasn't a transaction between the city code enforcement officer and Mr. Lal, or Veronica or Victoria or whatever her name was, or the employee that actually posted the ad who's no longer with Tea Time. Okay. But what I'm saying is that doesn't necessarily mean that money made it to my clients. And I don't know that it didn't. I don't know they would have accepted it.
Thank you. I understand that. And just so we're clear, the ordinance does not say money has to change hands.
Sure.
The ordinance is pretty clear that accepting a inquiry or reservation is the same. The city says that is the same as operating. Patrick, if you want to fill in any detail there, please do.
Yes, thank you, Chair. With that admin regulation that was dated 7/2017, I believe it was, goes into a little bit more definition what they consider operations. So that admin regulation is on our website as well, but that definition further goes into defining operation as advertisement and three other, a total of 3 points in that admin reg, which is also on the staff report page item 4-3. Yeah.
And there's payment of the TOT, which obviously wasn't paid.
Well, if I may, again, I think that there's a big difference between that on somebody where, you know, the only evidence is that there was possibly one other prior stayer and the person with 62 reviews. And again, when it was found that this was being done, my clients took quick and swift action to put an end to it, because it was nothing that they ever contemplated to begin with. And again, I think we're overlooking the obvious on the ordinance here that doesn't require it to be the owners. It requires it to be any person who does it. My clients, the owners of that property, did not engage in operations of a short-term rental.
Thank you. All right. At this point, any board members have questions for the appellant? Let's start with Mr. Hedrick.
Mr. Irwin, was there any type of agreement or contract between Tea Time and the owner?
Not that I have seen to this point, nor was it requested, so I didn't dig into it. I think it was, again, through the chair, Mr. Hedrick, I appreciate the question. I think that, again, this was supposed to be a due diligence deal, in that Tea Time was supposed to do a marketing review of it, take a look at what the long-term rental operations would be. This is a long-term friend and neighbor of Mr. Rosenfeld and Miss Keys. I don't believe that it had gotten to the point of a contract at this point, other than for him to look into it, and then his employee took a unilateral step on their own. So as far as I know, there was no agreement, because there wasn't anything in place at that point, other than go see what our options are for long-term rental.
So you're alleging that Tea Time fraudulently rented the apartment.
That's exactly what I'm alleging. And fraud is a legal, pardon me, through the chair, Mr. Hedrick, fraud is a legal conclusion. It's a legal standard. I don't know if it meets the legal elements of fraud. What I'm saying is that it was posted, that ad was posted, and any reservation taken was done so without the knowledge or consent and in violation of the explicit desires and wishes and goals of the owners.
Anything else, Mr. Hedrick?
No, I'm going to let Mr. Moses chime in.
Mr. Moses.
What I'm here, I'm a lawyer too, or I was trained as one, Mr. Irwin. I think there's enough discussion of possible fraud and criminal activity that we should suspend the decision of this matter and refer it to the city attorney.
Through the chair, Mr. Moses, first of all, I would have
Or
to
the
ask,
district attorney, sorry.
first I'd have to ask, how am I doing? Being that you're former, no, forgive me. You know, that would be something that would be probably not something within the desires of my clients. Again, we're talking about their neighbor, we're talking about a long-term friend. And again, we're talking about an employee that had worked and operated outside the instructions of the owner of Tea Time. That, my understanding is that employee is no longer employed. I don't know that for a fact. It's what I understand. It's what I hear. I didn't ask about their employment operations. I don't know that there's enough there that the DA would want to get involved. I don't know what DA you would look at. Would that be the DA in Sacramento? Would it be the DA in Palm Springs? And again, I don't necessarily know that that would be, that this is a situation where that would be. Fraud is the making a statement of material fact that they know to be, or should know to be untrue for the purpose of inducing a party to do one thing or not do another for which they have a legal right, and do so to their damages. And, you know, other than this proceeding, the damages are between, it would be a civil issue between Mr. Lal and Mr. Rosenfeld and Ms. Keys. I hope that answered your question.
Anything else? Anything else, Mr. Moses?
No.
Thank you. Mr. Sinclair?
Nothing.
Mr. Basili?
Yeah, I just have one comment. I'm kind of stuck on this right now. The attorney had mentioned that they were given, that the owners gave explicit instructions not to rent this property. And I find it really hard that someone would go against those requests for someone. Yeah, it might have been a mistake, but it's just, it seems illogical to me that if I was told not to do something, to turn around and do the opposite. So it's just a comment. It's sitting with me and it doesn't sit right. It's just, it sounds rather strange that someone would totally, against the request of someone else, do something, and in some case cause some sort of harm, which is what we're discussing right now. So it's just, it just seems kind of illogical that someone would do that. So that's all I wanted to say.
Through the chair, Mr. Basili, if I may address your comment, I think it's a fair comment. I think it's a fair point. And I'd address it this way. And Mr. Moses, you can jump in if you want to correct me here, because I haven't been doing this very long. But what I would say to that is that is why in tort, at least, unlawful acts are unforeseeable because they don't make sense. And again, we're not talking, and by the way, I don't think that there was necessarily any malicious intent by the young man that posted it.
Sure.
I think that he got, this is the business that Mr. Lal does. And again, I don't know enough about his business, Mr. Basili, and I apologize.
Sure.
But what I you get 5 properties in that you just brought on that you're going to be managing, right? You package them up, you distribute them to your team, and you got your notes, and mistakes happen. But what I can speak to, and the people that I can speak for, and the only people that I can represent for are Ms. Keys and Mr. Rosenfeld, and their instructions were clear. Mr. Lal, in his declaration under penalty of perjury, states it was very clear that Mr. Rosenfeld and Ms. Keys made it very clear to him, no short-term rental. And so we can scratch our heads all we want. There is plenty in this world that we can scratch our heads over.
Right.
But I think that what the evidence is before you, which is what I'm hoping and I believe and expect that the fairness of this board will look at, states that the owners of this property made it very clear these are our desires. And Mr. Lal, the person who's in charge of making sure that those wishes were taken care of, is where that fell apart. And he admits that those were in fact his instructions.
Right. And let me just comment. Let me make a comment to your comment. And that is that you're telling us this, but we have no proof that a letter was generated explicitly giving that person instructions not to list this property. So we're just going off of someone else is saying that this is what was done. So you're asking us to make a decision, but you're also giving us information. And as an attorney, you need to give facts. And so we don't have a letter. We don't have anything. I'd imagine that you would have, on your rebuttal, you would have presented this letter stating that the owners explicitly gave this gentleman that was fired, supposedly fired, not to list the property.
I'm sorry, if I may, through the chair, Mr. Baselli, the declaration from Mr. Law is in your packet.
Okay.
This is the letter that you're talking about where he signs under penalty of perjury.
Okay, I
Okay,
apologize. I didn't see that. Sorry.
And
I didn't see
and now
that.
paragraph 9, well, if I may, just to read it into the record, paragraph 8 and 9. Once he bought the property at 2965 Avery Drive, he asked me what kind of opportunity there was to derive some rental income for time when the property would not be used for extended periods of time. Ken told me he and Kimberly were only interested in rentals of 30 days or more. They did not wish to deal with the complications associated with short-term rentals. Complications he cited include problems relating to maintenance and operation, short-term renting, scheduling complications in regard to their personal use, and regulatory complications both with the city and the HOA. Paragraph 9. I agreed to market the property with adherence to the owner's explicit instructions not to market to or accept short-term renters. I assigned the property to an employee who with those same explicit instructions. The employee failed to follow those instructions and the property went up on Airbnb short-term page rather than on the long-term sites of 30 days or longer as instructed.
Okay, I apologize. I didn't see that letter. When was that letter dated anyway? Because I don't have it in front of me.
The declaration was signed by Mr. Law on 5/18.
Okay, thank you.
Vice Chair Kane, any questions for the appellant?
Not for the appellant. I have questions for the city attorney.
All right, hang on for just a second, if you will. Mr. Hedrick, did you have a question for the appellant?
No, also for the city attorney.
All right, let's let Vice Chair Kane ask her question.
Are we doing this when we close the hearing? Are we doing this?
Well, if Mr. Irwin will have an opportunity to respond, so.
He will. Okay, well then the question to the city attorney, who now went off camera, oh, there she is, I mean, we've never seen this before. I think this is really intriguing. It's been stated that there's no written agreement between the operator, as it were, the manager of the property and the owners. But I feel like the legislation, the ordinance that we're under isn't chaos. This is not a legal proceeding. This is administrative hearing. And I feel like I need some guidance from you regarding the ordinance with respect to what's going on here.
Yes, yeah, I just want to remind you that, you know, my role with the board is in an advisory capacity, not like the previous attorney that you were not part of. But yeah, I mean, this is not a hearing where there's formal rules of evidence. We have testimony on both sides about what happened, and then it's your job to weigh that and make a decision based on what the ordinance says. So if you have a specific question on the ordinance and the city's interpretation of that, I would be happy to answer that.
So Ms. Tremblay, can you maybe speak, and maybe this will kind of go to Vice Chair Kane's question. We have had cases in the past where a third party set up an ad and the homeowner was still, based on the ordinance, was still accountable. Can you speak to that from the ordinance?
Right, that is the issue of agency, and that is found in section 5.25.050. In subsection A, the last sentence says the failure of an agent to comply with this chapter shall not relieve the owner or the owner of the owner's obligations under the provisions of this chapter. So we've seen other cases, you know, where there's an agency relationship, and ultimately the city's interpretation of the ordinance is that the owner is ultimately responsible for violations, including the operation without a vacation rental permit. the city expects all the owners of properties in the city of Palm Springs, if they're operating short term, they obviously have to get this permit prior to operation. If they're renting long term, they're responsible to know when they have different tenants coming in, and just be aware of what's going on at their property that's within the city. So if there's an owner and they don't seem, we had testimony on one side saying that there hasn't been short-term rentals. There's testimony also that there have been. So the city expects owners to know whether or not their property is being rented short-term, and that the section on agency is what occurs when there's a failure on the agent's part to comply with the ordinance.
Okay, well, that's exactly what I was talking about. I guess it's called agency. And so that answers my question.
Mr. Hedrick, did you have a question for the city attorney?
Mr. Chair, can I respond to Ms. Tremblay's response?
I'm sorry, let's let Mr. Hedrick ask her a question, and then I will give you an opportunity to respond to both.
Thank you.
So I think the city attorney just did a great job, because you're right. We've had similar situations where people have rented the property before the permit. Agents have rented the property before permits were obtained, or did other illegal activities against. And I think that there was an implied agency contract between the owner and Tea Time, because they got the keys. So, if there are any damages, it's between those two. I think the city ordinance is pretty clear.
Mr. Oren, if you want to respond briefly, please.
Mr. Chair, absolutely. Again, there is a conflict in your statute, because he says any person who operates a vacation rental does not imply the owner. Secondly, you don't have any evidence. You have implication, you have thoughts, you have Ms. Tremblay's learned opinion, which I think is important, but you have no evidence that refutes or rebuts what I'm saying, which is there was no agency contract here. There was a, hey, check this out for what our opportunities are long-term. Do your marketing research. And it's great that you guys are speculating that, oh, well, maybe it means this, maybe it means that. But whether it be an administrative case or whether it be a Supreme Court case, all law where a state actor, state entity, which a city is, has to arise its authority from the Constitution. The Constitution says that where the state is looking to deprive a party of liberty or property, they are entitled to due process rights. I understand this isn't a legal proceeding, which is why I hadn't been objecting left and right throughout the entire process. But there is still a burden of proof. And that burden of proof has got to be based on evidence. There is no evidence that your code enforcer had made any linkage to my clients, the owners of this property. There is no evidence that there is an agency contract in place here. In fact, the only evidence that you have is my testimony under oath that there isn't. And so there was no agency. This was a friend dealing with a friend saying, hey, go check this out for me. It went wrong. And as soon as it was determined that it went wrong, it was dealt with.
Let me correct you, sir, that paragraph 9 of the declaration by Mr. Akashi, is it says he was signed a contract to market it.
Paragraph signs, I agreed to market the property.
There you go.
With adherence to the owner's explicit instructions not to market it or accept it to short-term renters.
He violated the instructions.
I think what this shows is that this was an honest and misguided statement by him. There was no agreement. The agreement was to identify the market opportunities. And if he miswrote it, it was a Scrivener's error. But again, I think we're trying to find out how do we shape and form and sand this square peg down so it fits into the round hole. And I, with due respect,
I think your client's peg is in the hole in this case, sir.
All right, thank you. We will close the public testimony portion of this hearing. Next section is for the board to discuss what we've heard from both sides. Why don't we start with Vice Chair Kane?
I pass and have someone else start.
All right, I'm happy to start. You know, I think we've heard a lot on both sides. I think based on the letter from Mr. Lal, there was, whether verbal or written, there was some sort of an agreement between these two. And Mr. Lal, whether took it upon himself or a staff member of his, chose to list it as a short term. Now, I think, you know, we have been through many, many cases like this, and it is without dispute that the onus falls on the owner. We don't have testimony that they got some revenue out of this, but we don't have testimony that they didn't. I find it not very plausible that this person who apparently manages other units would have taken revenue and not given it to the owner. So the owner should have, in my mind, done a little bit of due diligence, say, where's this revenue coming from? We told you not to rent it. Then also when the compliance officer reached out about a short term and that was responded to in an affirmative, we have been through this over and over again. That is from the city's perspective, the way the ordinance is written, that's all it takes. So that is my perspective. I think the owners, you know, may have a case against Mr. Lal and his former employee, but that's between them. That doesn't involve us. The fact of the matter is the owner is responsible. And I think what we've seen from both sides is they rented it. They rented it short term without a permit. And so I will cede to my other board members. Mr. Sinclair, any discussion?
I was just going to say, I agree with Stephen. I mean, Mr. Lal's declaration, and you know, I practiced law for 42 years, so I know a little bit about law. I agreed to market the property. So I assigned the property to an employee. So there was obviously an agency created. And perhaps Mr. Lal, if we do uphold the fine, maybe he's willing to pay this fine. I don't know. But we've been through this so many times with someone else doing the rental without the knowledge of the owner. And so you know, it's as many cases we've had on this, it's easy for me to make my vote.
Vice Chair Kane, you want to weigh in yet?
I'm following along just fine. I think everyone is, I mean, I think I understand this. Yes, we have been through this in a certain way that's similar. I've never personally heard somebody say, I didn't know someone else was doing this rental, but regardless, I agree with what I've heard thus far. And that's all I got to say.
Mr. Vasili?
No more comments. I'm done.
Thank you, Mr. Moses.
I think I've made it clear.
All right. All right, then we will move on. Is there a board member that would like to make a motion?
I move we uphold the fine and the buy-in.
There's a second.
Second.
Thank you. City Clerk, can you call the vote, please?
Board Member Moses,
Aye.
Board Member Sinclair,
Aye.
Board Member Vasili,
Aye.
Vice Chair Kane,
Aye.
Chair Panessa.
Aye.
Motion carries 5-0 to uphold.
All right. Again, I want to thank everybody for their time and effort. Mr.
Chair,
Irwin.
if I may, I'm going to ask that the board preserve this record. I don't know if you transcribe it into written word, but I'd like to be able to figure out what I need to do, get a recording, and let you
This
know
has
that we
all
will be
been
challenging
recorded,
this
so,
we will be challenging this for judicial review.
And that is your right. This has all been recorded, so you can work with the city clerk to access
We
that.
would ask that the board stay the fine until such time as we can have it reviewed by the court.
That is not in our jurisdiction or ability to do, so unfortunately, that is not possible.
What is the
So-
time on paying the fine?
That will be communicated to the owners of the property from the city clerk on how they wish to pay the fine.
And they are lenient about making terms of payment.
So also, they are not prohibited from renting it long-term. They are permanently ineligible to rent it short-term. They are not prohibited from renting long-term. Again, I'd like to thank everybody for their effort on this case. And we will move on in the agenda now.
Thank you, ladies and gentlemen.
Thank you. All right, item number 6, this time is set aside for any general comments, announcements, requests of staff and or other issues of concern from the board members. Any board members have anything they'd like to bring up? Mr. Hedrick.
I'd like to commend the staff on the New York Times article that appeared last month about vacation rentals. I thought it was reflected very well on the city of Palm Springs and our vacation policy. Mr. Williams was mentioned several times, and congratulations.
That's nice. Mr. Moses.
2 things. I'd like to see us get back into the some kind of a room where we can act more judiciously and not be fumbling with computers and being distracted. The city council now has its hearings open, and I think it's time for us to meet again
So we have been waiting. We were waiting for the city council to hold meetings in public in person first, and then we would be following. So it is possible that one of our next meetings will be held in person.
Yeah, the other thing, what happened to the Pledge of Allegiance? Didn't we used to start with the Pledge of Allegiance?
We always did. That was taken off the agenda about a year ago, and I'm not sure why.
If the board would like to see that on the agenda, I can include it in future agendas.
Anybody else?
I didn't understand that.
She said if the board would like that put back on the agenda, she can add it back. Anybody else have any opinion on that?
No objection.
Mr. Moses, are you saying you'd like it back on the agenda?
I would like it back on the agenda.
All right.
It lends a certain aura to the presentation.
All right. I have no objection. Anybody else? All right. Thank you. Monique, if you can add it back, that would be great. Anybody else have any comments?
Just a good letter from Stephen to the Desert Sun this morning.
Yes, thank you for reading it.
All right, now let's move on to number 7, time set aside for the city attorney to update the Administrative Appeals Board on important items initiated by staff or previously requested by the board.
Good evening, everyone.
All right.
I want to just let you know that on March 29th, the City Council had a workshop meeting and discussed some possible updates to the vacation rental ordinance. And I believe that staff is organize a community and stakeholder group to help with that as well.
Is there any member of the appeals board that is involved with that?
I don't know exactly how it will be set up, but when we do have groups like this, sometimes a council member or like a member of this board perhaps could go as a representative of the board.
I would think that would be great.
So was there substantive conversation around amendments to the ordinance?
I just have a few notes on it. I guess there was some conversation about kind of tightening up the concept of vacation rentals being incidental uses. as opposed to people buying them for the sole purpose of just renting them out. And there was also some talk about like secondary impacts, the noise, parking, that kind of thing. But that's all the information that I got on that.
And so the action at the council was to create a working group or something?
I think staff's going to be working on that to out and get that going.
So is that Patrick or Veronica?
I believe I'm not sure who's assigned to it, but I would think that Veronica is probably heading up that or delegating it to someone.
Patrick, do you have a comment?
Yeah, first, let me check with Monique. Am I allowed to comment on like just probably not? Just want to make sure that I'm not violating anything. I guess I could say first.
That's all right. Go ahead.
Okay. Attorney Tremblay is correct. There was that vacation rental meeting. I believe it was a study session you're referring to that we held. I presented data to the city council regarding that. That is all public. The conversations that were just simply conversations. There was no policy driven points to do this or do that. We are looking to from the points that council talked about with, from my notes was regarding ancillary uses, density, stuff like that. We are looking to create focus work groups with everyone in the community to start that conversation to then later at some time maybe provide policy recommendations to council to make decisions on. But right now that was just discussion and we're at the point where we're creating the groups or trying to design a process to how to get that started. And that's where we're at right now as far as creating work groups and stuff is just getting the implementation started and then really looking to hopefully have it all wrapped up by maybe the end of the year. But I mean, it's all really discussion, but that is the goal is work groups and to have a broad discussion with all sides of the board in the community.
Okay, and so I don't scour the city council agendas, and I don't know if there's any way for us to get like notice or something like or is it just on me to keep track?
Well, I do know we were going to communicate that one from our office regarding sending out to everybody that signed up on our stakeholder mailing list. You'll see communication there. I believe our neighborhoods department's also going to be communicating such out to everyone too, because the entire goal is if we're going to present any kind of recommendations, we want to have input from everyone. So we do first want to make sure to communicate this process to everybody.
Okay.
Anything else, Jill?
No, that's all I had.
All right, thank you. Last item on the agenda is the city clerk's reports. This time is set aside for the city clerk to update the Administrative Appeals Board on important items initiated by the staff or previously requested by the board.
Yes, so for those of you who tuned into our last city council meeting, we are in the process of reviewing boards and commissions and streamlining the functionality and communications between staff and our boards and commissions. There will be a joint city council meeting on June 21st, which is scheduled for boards and commissions who have priorities aligning with the city council's strategic plan. It is not clear to me yet whether the AAB will be invited to participate in that specific meeting, but we will be reaching out to board members within the coming weeks for input on different aspects of that review.
All right, thank you. Anything else?
Next meeting.
Next meeting's on your agenda. It's June 22nd at 5:30.
Okay. Motion to adjourn.
Somebody second it, please.
Second.
Thank you. All right, everybody. Thank you for your effort and time. Have a good rest of your month. We will see you next month.
Thank you.
Chair Panessa,
Yes, ma'am.
I am locked out of my iPad, but I did make you co-host. Are you able to stop the recording?
Let me see. Pause or stop recording.